an act concerning guardians ad litem and attorneys for minor children in family relations matters.
Last Friday evening, the Senate was first to consider compromise legislation addressing serious issues raised about Connecticut's family court system. A strike-all amendment was offered on Senate Bill 494, which came about through bipartisan negotiations between legislators, the judicial branch, and others. At issue, the practices and fees of court-appointed guardians ad litem and attorneys for minor children in contested child custody cases. Hours and hours of public testimony, heard first by a task force created to review the system, followed by the Judiciary Committee, brought the problems to light.
Much of the criticisms and the issues that have been raised had to do with how guardian ad litems and attorneys for minor children are appointed in the court system, what their role is, how are they to be paid, and how much they are to be paid, who oversees the performance of their work, and some other issues. And what this amendment seeks to do is to add some structure and to address all of those questions and all of those issues that have been raised.
Included in the compromise legislation, the court will be required to offer parents in conflict a list of 15 potential guardians ad litem or attorneys for the minor child to choose from, but will be authorized to appoint one if the parties do not reach agreement within 2 weeks. Also, the court will be required to present a proposal to all parties involved for scope of work, including deadlines and fee schedules pertaining to the GALs and AMCs.
For the first time, if this bill is passed, the parties will have standing to file a motion to remove a guardian ad litem or attorney for the minor child. This has been a point of great contention and insistence by the advocates of reform, who were frustrated because some of them actually believed that some guardian ad litems were biased, retaliatory, and they even felt at times that the system was corrupt. The court would be prohibited from ordering a guardian ad litem or attorney for the minor child fees to be paid from college savings accounts or other exempt assets, or from credit cards if it is determined that the parties have an inability to pay. And finally, the judicial branch would be responsible for developing a code of conduct for attorneys for the minor children and guardian ad litems to follow. Madam President, as I indicated, this, in the minds of some people, will be viewed as a minor step or a small step, but considering all of the parties that came together and sat around the table to hammer out these issues, I believe it is a significant step forward, and I have confidence and optimism that it will serve to improve and alleviate some of the complaints that have been raised and brought to the Judiciary Committee and all of you during this particular session.
We had a public hearing that went from 10 in the morning till midnight. And when you think that the members of the public spoke on average for about 5 minutes apiece, you can imagine how many people came and testified that there were real problems. That in some areas of the state it was almost incestuous, and that there was self-dealing, and bills were generated in the tens of thousands of dollars, and people lost their homes, their retirement accounts, college funds. And how, at the end of the day, can the system that does that to people be working towards the best interests of children? It cannot. Now, we have a saying in this circle: don't let the perfect be the enemy of the good. And I know there's going to be people that leave here this evening saying, well, it really doesn't do that much. It does a lot. in my humble opinion. Because we're going from a fairly unfettered, unregulated, almost Wild West situation where we are trusting individuals to act honestly and appropriately to a new world where there will be constructs and oversight and checks and balances.
Who is blamed for the system out of control? We are. We were. I would suggest the family bar is also to blame. I would suggest judges are to blame. And the system got so out of hand, it took the people from the outside to come and tell their stories. As stressful and as emotional as they were, they came and they told their stories. And I think this body and the judicial branch came and said, let's sit down and see what we could do. I hope that the message to the Family Bar Association and to judiciary is this is a big step. There are a lot of other things we'd like to see that's not in this bill. Cap on GAL fees. Travel time not being charged on a GAL fee. But what we're going to do at this point is say, we've gotten a good start, but we're watching. We don't like to interfere that much, and we don't like to interfere with our equal branch, but we will where there's a need. And we will when we see abuse.
I think that this amendment really does address the core of the problem as it has been perceived and articulated, and certainly urge adoption of the amendment.
As I came into my last session in the State Senate, this was the only bill I wanted to see pass. And I am so happy that we are here today. I think we have a lot more to do. I said earlier, I think this is positive steps in the right direction, but still falls short of where we will be to reform what is a system that needs a lot of change.
I rise really just to thank the members of the public who shined a bright light on a very significant problem. And because of their efforts, that is being addressed today, and I want to thank them for their courage and persistence in coming forward.
The Senate passed the amended bill unanimously, and it was sent to the House for immediate consideration later that night.
This bill began as part of a task force that we passed last year, which was formed to study the issue of guardians ad litem and their role in our family courts. To all of the members of the task force, two of our colleagues, Representative Gonzalez, Representative Vargas, served on the task force, but also there was attorneys and others who have a direct interest in terms of how the system works and how our family courts operate. And I think they all deserve a significant amount of our appreciation for the time and effort that they put in, and is hopeful that they will be satisfied with the end result.
Just wanted to take this opportunity again to echo some of the sentiments that Chairman Fox had certainly indicated, thanking the task force for all of the good work that they did and the long hours also of testimony that they heard, and also all of the members of the Judiciary Committee that stayed for the lengthy public hearing as well. But also to all of the public that took time from their lives to come up here and share their stories, both certainly in a positive way of their experiences with GALs and AMCs, and also some of the negative stories that they shared as well. So I certainly wanted to thank them.
Unfortunately, there's always a few bad apples in every system, and I'm hoping that this bill, this GAL bill that we are considering for approval on the floor, will go a long way in correcting the abuses in the system.
The final comments of the night came from the legislature's chief advocate for change in the family court system, Representative Minnie Gonzalez of Hartford.
This is an issue that is very important to me. I invest 4 years of my time trying to bring some changes to the court system. And I recognize that sometimes I get very emotional. But thank you very much for all your support and all your help. One of the biggest problems is that is no cap on this bill. Family cases and parents end up paying $200,000, $300,000, $400,000 of thousands of dollars. That's a huge problem. It's all about money. These parents are paid, the guardians ad litem in the ANC. They are paying, as the parents, we're paying to the guardians ad litem in the ANC, they kids' college. And those parents are losing kids' college fund. I know this is changes at the beginning for a better system. I'm not giving up. I'm planning to come back next year, if God permit. And for those parents and for those kids that are suffering, I urge my colleague to support this bill.
The final vote in the House was also unanimous. It goes to Governor Malloy now for his signature.